According to the cloud. We're doing all the things here. So welcome everyone, and thank you for joining us for this workshop on protecting your ideas, inventions, and intellectual property during pitch competitions. My name's Cameron Law, and I serve as the executive director here at the Carlson Center for Innovation and Entrepreneurship at Sac State. I'm joined by one of our team members, Arlene Miranda, who's there on screen, given the waves there. She heads up our marketing and operations efforts. So likely if you saw our posts or our newsletter or many other things, that was created by her. So glad we're getting the word out to all of you. We at the Carlson Center serve as a regional hub and platform for providing approachable and accessible entrepreneurial education, community, and support to enable startup founders of all backgrounds to start and scale their businesses. And we're really excited to partner with the Office of Innovation and Technology Transfer here on campus to host this workshop on how you can protect your ideas during pitch competitions. And we have Raphael Sinclair, who is the Technology Transfer Officer here at Sac State, and a very seasoned one who's worked with many startups and founders in understanding their IP and a variety of things at different institutions. And without further ado, I'll turn it over to Raphael, who will lead us here today. If you do have any questions, feel free to throw them in the chat. I'll be helping facilitate those in, or if you want to use that raised hand feature, feel free to do so. But in the meantime, while we pass it over to Raphael, feel free to throw in the chat where you're joining us from and what you're excited to learn. But take it away, Raphael, and appreciate you all being here.
Thank you very much for joining today's workshop. Do you see my screen?
You got it.
Okay, so you can see the slide deck now, right?
You got it. You're good to go.
Okay. We have one question, one topic in the chat. I will cover that, protecting your company name. And Cameron, if you see something that pops up in the chat, please let me know, because I'll be looking at the slides.
Perfect.
Okay. So for today, we're gonna talk about the 5 types of IP, but I'm mainly going to focus on patents and somewhat on copyrights, and more so on trademarks than on copyrights. Go through 2 or 3 case studies. Then we're going to talk about protecting your ideas, inventions, and IP during pitch competitions, and then save your questions to the end unless you can. It really can't wait. Okay, so let's get started. Okay, so there's a disclaimer there. You can read it later on your own. Okay, so what's IP? Okay, IP isn't real property. It's not personal property. It's a product of the human mind. Okay, and there are 5 types of IP out there: trade secrets, copyrights, trademarks, plant breeder rights, and patents. And before I can go on and let you know how to protect your IP and your inventions and ideas in a pitch competition, you need to have an understanding of what IP is. Okay, so trade secrets, there's a law that was adopted some time ago, the Uniform Trade Secrets Act. Okay, and this is how that act defines trade secrets. And I'll simplify that for you. So basically, a trade secret, it's information that has actual potential independent economic value because it isn't generally known to everybody. Okay, and it has economic value to other persons who can't get that information legitimately. And a trade secret is subject to reasonable efforts to keep that information secret. Okay, so here are some examples of trade secrets. Okay, and some of you may ask, well, why doesn't someone get a patent on the formula for Dawn or for Listerine or for the recipe for Coca-Cola? Well, in order to get a patent, you submit a patent application and you make that known to the world, and you get basically a 20-year time period to exclude anyone from using that invention. But then afterwards, when the patent expires, everybody can use it. So a lot of companies choose to keep certain things a trade secret so they can keep making money off of it forever. Like I think Coca-Cola has been around for well over 120, 125 years. So I mentioned the Uniform Trade Secrets Act, okay? That was enacted way back in '79. It's been amended a couple of times, and 48 states have adopted it, including California. Recently, 7 years ago, almost, the Defend Trade Secrets Act was enacted, okay? And what's important about this is that it was done to align federal law with the Uniform Trade Secrets Act that was adopted by the states. And the main thing that this does is it allows trade secret owners to sue in federal court over the misappropriation of trade secrets. Before, they could only sue in state courts. California adopted the Uniform Trade Secrets Act. And you can look it up there if you like, when you have some time. Okay, so the important thing to take away from this is that trade secrets are not registered with any government agency, okay? But a trade secret could be the most valuable thing that a business or an owner has. And the most important thing about trade secrets is you have to maintain the confidentiality of that trade secret. And believe it or not, I have worked with startups who had trade secrets. One of them was a group of faculty and researchers at the University of Hawaii who came up with software for predicting how much solar power could be, electricity could be generated from solar panels 15 minutes ahead of time, based on cloud coverage, based on data from a satellite up in space. And we licensed that technology to their startup company. They developed it, and the University of Hawaii, I did the license it to their company. And we decided to keep it a trade secret because we thought that was the best way to protect it, which is kind of unusual because universities usually don't keep trade secrets. Okay, so the next type of IP I'll talk about will be copyrights. And copyrights give owners these 6 basic rights here. So some examples of copyrights are over here on this next slide. But the most important ones that I want you to take away from here are software and your websites, because software is protected by copyright. Software could also be protected by patent law, but getting copyright registration is a whole lot cheaper than getting a patent. Plus, the protection from copyrights lasts a whole lot longer than the protection from a patent. So with copyright law, you get the protection as soon as that work is in a fixed, tangible medium. Software is considered a literary work, okay? But you get the protection of copyright. If you come up with some software, come up with an app, you can register that with the Library of Congress, and you'll get additional protections from that. And the registration fees are relatively inexpensive, $45 to $500 compared to a patent application, which can cost tens of thousands of dollars to get. Okay, so when you register it with the U.S. Copyright Office, the additional protections that you get is you can sue not just for economic damages, but you can sue for punitive damages, as well as sue to recover your legal costs. If you don't register your copyright, you can't sue for those 2 things. And with copyright law, you get the protection as soon as you create the work and put it in a fixed, tangible medium. So things to take away about copyrights are you have to put it in a fixed, tangible medium to get that protection, whether it's in writing, whether it's in electronically in a computer file. It's always a good idea to register your copyright if you're going to commercialize your software or your work. And you should always put a copyright notice on your software or your work or your book or your music. And here's some examples of copyright notices. Okay, trademarks. Someone asked the question of how do they protect their company name? Okay, so this is how you would do that. And a trademark can be any symbols, words, slogans, colors, or combination of those things. But what a trademark does is it identifies your entity, it identifies you, identifies your product. It enables customers to recognize your products, your services, and how to differentiate those from other products and services that are out there. Okay, these are some examples of trademarks that are out there. Okay, other examples are business names, colors, domain names. Now you can't just get a trademark on a color, okay? It has to be in combination with something. For example, Christian Louboutin shoes, okay? They trademark the red soles on their shoes. So if you're going to start selling shoes and you start putting red soles on them, you're infringing on Christian Louboutin's trademark. You can trademark phrases, even scents. For example, it used to be at Verizon stores, they had a flowery musk smell when you went in there at some of their Verizon stores. Well, if T-Mobile was selling phones, they couldn't have that flowery musk smell. You can get a trademark on sounds, okay? So the trademark, as I mentioned, it protects your logo, your design. It also identifies your products and services, it distinguishes them from others. But in addition to that, there's also trade dress protection that you get. For example, the way you package your product, like a Coca-Cola bottle is one example of a product that's protected by trade dress. If you're selling soda pop, Coca-Cola, you can't use the same type of bottle that Coca-Cola uses, okay? And the greatest thing about trademark protection is that it lasts forever, unlike a patent, which only lasts for 20 years usually, or copyright, which lasts for 75 years, lasts for the life of the creator plus 75 years. Now you're going to get these slides, and a lot of the slides are hidden because I only had 60 minutes, but there's some additional information in those slides that are hidden that you'll be able to see in case you have additional questions about copyrights. For example, you have a store and you play music in the store, there's information on those slides as to how you can do that without infringing on someone's copyrights, okay? So trademark rights are created by common law when you start using them in business and commerce, okay? When you start selling products under a certain name, when you start doing services under a certain name. There's also federal registration that will help you get additional protection for your trademark, because in common law, it's based on your region, okay, your geographic area. But if you're going to be doing business outside of California, then you want to register your trademark with the federal government so you get that protection for all 50 states, the 14 U.S. territories, and Washington, D.C. Yes, there are 14 U.S. territories, but only 5 of those territories are permanently inhabited. So, with trademark registration, it's necessary if you're going to be doing interstate commerce, as I mentioned before. It grants you protection, more protection than if you just register it with your state agency, because it allows you to sue in federal court. So that's really important. And really, another thing that's important is it enables the recordation of registration with the U.S. Customs and Border Protection, because one of the missions of U.S. Customs and Border Protection is they inspect products that come into the U.S. and they see you have a trademark on a certain product, they can stop counterfeit products from coming into the United States. Okay, you can't do that without getting the federal registration, and it's relatively inexpensive, only $250 to $350 per international class per trademark. Okay, and that is for lifetime protection, but every 10 years you have to pay an additional fee to renew it. Actually, after 5 years, you got to pay the fee, and then afterwards it's every 10 years. Okay, and you can, again, you can register your trademarks and service marks with your state agency. That's on the slide is where you go for the state of California. Just click on that hyperlink that's in there. So if you have a product, if you have a service, and you haven't registered it yet, but you're using it in business, start identifying your name of your product, the name of your company with the TM. Okay, if it's a service, use the SM. After you've gotten the federal registration, then you can use the little R, and you can actually put that R anywhere. Okay, but most people will put it on the right side of their trademark, and you get the trademark registration from the U.S. Patent and Trademark Office. Okay, so the things to take away from here regarding trademarks is you register with your state agency, register with the USPTO, let others know that you're intending to use that trademark by using the symbols TM or SM, and then once you got it fully registered with the federal government, then you can start using the R. Okay. The fourth type of IP is plant breeder rights. This is the only slide I'm going to show you. There are a couple of hidden slides because I don't think any of you are into plants and trees. If there are, please put it in the chat and camera, let me know. I see there are quite a few things in the chat. Let's see.
So there was one related to biotech, which I don't know if that's closer to plant breeder rights than some of the others.
Where is it?
So it says, what is the first and number one critical step in safeguarding your innovation regarding biotech?
Okay, actually, that applies to safeguarding your innovation with other things too. But there's one additional thing that you should do with biotech, and I'm going to cover that. Okay. Okay.
Sounds good. There was let's see what if there was one other additional question. I think we're looking good.
Okay, good. Okay, with patent law is designed to encourage inventors to disclose their inventions to the whole world. And in exchange for doing so, they get a time-limited period of monopoly to exclude others from making, using, selling, offering for sale, or importing that product, that invention. Okay, and inventors or owners of invention, they have to file a patent application for their invention with the U.S. Patent and Trademark Office or Foreign Patent Office. Okay, in order to get that patent, in order to get that protection from the patent. Unlike copyrights where your protection is automatic, that's not true of an invention. You have to get a patent, okay? And for the USPTO to grant a patent on an invention, the invention has to be useful, it has to be novel and non-obvious to a person of ordinary skill in the relevant technology or art. And there are 3 types of patents out there: design patent, plant patents, and utility patents. We'll focus more on design patents and even more on utility patents. Okay, so for a design patent, it's for someone who invents a novel, useful, non-obvious ornamental design of a functional object. Okay, examples of this are the Coca-Cola bottle, a cell phone case, an emoji, a fashion accessories, furniture, even monuments. A couple of weeks ago, I think it was 3 weeks ago, I talked to a student here who came up with a new type of wallet, and he decided that he might consider getting a design patent that wallet. For example, I mentioned the Coca-Cola bottle. The patent on that's only one page. It's relatively simple. It's a design patent. Okay. Same thing for the patent on the Statue of Liberty. Now, these design patents have long expired. Okay. However, with the Coca-Cola bottle, they get protection under trademark law as trade dress. I mentioned that earlier. And the Statue of Liberty, even after the design patent expired, it still have protection under copyright law, which has long since expired. Okay, but again, the thing about design patents, it only protects an object's ornamental appearance, okay, which is why it's good for a fashion item like a purse or a lamp or something like that. But it doesn't protect the object's structure or utility. And unlike utility patents, which gives you 20 years of protection, you only get 15 from a design patent. However, it's a lot cheaper to get a design patent than a utility patent. Okay, there are plant patents that you can get on plants, and these are the rules for what you can get a plant patent for. It has main thing is it has to be asexually reproduced, and it can't be something like a potato or a yam. You could also get utility patents on strawberries. I served the UC Davis Tech Transfer Office for 19 years, and every year for decades, they've made millions of dollars in royalty revenue from their new varieties of strawberries. And you can, with some of them, you can get a utility patent. With some of them, you can get a plant patent. Okay, so utility patents, okay? Unlike a design patent, they generally expire 20 years from the filing date. Sometimes you get a little bit extra time, sometimes even a few more years if the patent office took too long to examine your patent application, okay? So to get a utility patent, the invention has to meet these 4 criteria. Inventors can only get one patent on one invention. You can't get a patent later on the same invention, okay? And the inventions must all be identified on the patent application. Don't exclude an inventor from that patent application if you think, oh, well, they only contribute 1 or 2%. You have to still list them. And besides, that 1 or 2% may be one of the most important things about your invention. And 2, you don't add people like, oh, I'm going to add my professor because he was very helpful. No, because if you exclude people that should be on that listed as inventors, or add people that aren't inventors, your patent can get challenged and it could be nullified. So don't do that, okay? It also has to be useful, and it also has to be eligible for patenting. There are lots of things that can't be patented. And here are some examples of things that you can't patent, okay? Cloned animals, isolated DNA, laws of nature. But the most important thing here on this list is the last thing, anything that has been previously publicly disclosed. So you got to be careful about disclosing your invention because you can lose your patent rights by disclosing it before you file a patent application. Okay. So again, there are 3 requirements for getting a patent: the utility requirement, the novelty requirement, and the non-obviousness requirement, okay? So the invention has to be useful, and I think practically all inventions are useful, okay? The invention has to be novel, okay? It must be clearly different from the prior art. Prior art is a term used in patent law, used by the patent office, and prior art means all information that's out there, including any information of the inventors that has been made available to the public in any form before a given date, okay? And a patent examiner can deny a patent application for a patent if that invention has been described in the prior art. And the prior art reference that the patent examiner uses will be a single document that discloses the entire invention within that single document. I've had faculty members who disclosed an invention to us at the University of Hawaii, at UC Davis. Before I came here, I was at the University of Hawaii for 3 years, okay? And the patent office used their own publication against them to try to deny a patent on their inventions. And they would cite, you disclosed this on this publication more than a year before you filed the patent application. That was already out there. And the third thing is the non-obvious requirement, okay? The invention can't be obvious to a person who has ordinary skill in that art or technology, okay? So when the examiner uses, wants to determine if something was non-obvious, they can use multiple documents and combine them together, unlike when the examiner is examining an invention for prior art to see if it was already disclosed out there. And one example is, say, for example, if I invent a three-legged stool and then someone else comes up with a four-legged chair. Well, you know, that could be obvious. You know, a four-legged stool, a stool with 4 legs, as opposed to a stool with 3 legs. Okay, so some things you want to think about before you file a patent application is, you know, you got to think of why do you want to patent your invention, okay? And here's some reasons why it makes sense to patent your invention, okay? And it's okay to commercialize your invention and get rich off of it. That's a great reason, okay? Okay. Another thing you want to consider is, what is the market potential for your invention? For 22 years, I served University of Hawaii and UC Davis combined. And I can tell you the vast majority of the inventions that they got patents on were commercially worthless. And that's not just true of those 2 institutions, but that's true of so many institutions out there. The vast majority of the inventions never get commercialized, but a few good ones will bring in lots of money. And I mentioned the example of the strawberries at UC Davis, which bring millions of dollars every year, okay? So another thing you want to consider is, how much money do you have to get a patent? In the US, it can cost anywhere from $10,000, $30,000 or more to get the patent issued when you include the legal fees involved. And also, if you decide to obtain a foreign patent, it can run into the 6 figures. And I've seen that happen at University of Hawaii and UC Davis, okay? The other thing you want to think about is, how strong is your patent, okay? In 2011, we had the America Invents Act, which was enacted into law, and it made it faster and cheaper to challenge weak patents. And 2 years later, we had the Innovation Act, which made it harder to enforce patents and easier to infringe patents. Some things are best protected by trade secrets if they could be easily worked around, okay? Also, you got to think about what countries you want to file in. 85% of all patents are granted in just a few countries in the European Union. And also, what type of patent application should you file? A provisional, which is only done in the US. It's a very inexpensive patent, which just lets the patent office know, hey, you come up with this invention, and later on, you can convert that a year later to a non-provisional. The non-provisional is the full-blown patent application. And then if you plan on filing internationally, you file a patent cooperation treaty application. Okay. Another thing is, do you want to get prioritized examination by paying a little bit of extra money? And it can be advantageous for startups, okay, doing this. It only costs you $1,000, okay? But you can it'll help you obtain foreign patents in a shorter time. And also, you might be able to get faster increase in company valuation, because you'll get that patent issued earlier, like you can get it done in like 12 months. And a lot of times patents take 3, sometimes 4 years to issue. Okay, so I've talked about the provisional, very inexpensive, $200 to file, but you have to convert that to a non-provisional within a year. Okay, what it does is it buys you time. You have a startup, you can try to raise money to be able to come up with the money to file the non-provisional in a year. You plan on filing internationally, you can file a patent cooperation treaty, okay, which isn't filed with the USPTO, it's filed with the World Intellectual Property Organization, and it allows you to file in up to 150 different countries later on, okay, and generally you have 18 months after filing that PCT application to decide which countries you want to file in. Now at the bottom, I said it extends the priority date by about 30 months. It gives you 30 more months. Well, that's only if you file a provisional first in the US, because you get those 12 months. So 12 plus 18 is the 30. Okay, so you want to protect your patent rights, okay? And this applies not just to biotech, but also to just about any other type of invention. Okay, so don't make an enabling public disclosure. An enabling disclosure is a disclosure that contains enough information in detail to enable someone skilled in that art to make or practice that invention. Okay, before you make an enabling public disclosure, talk to your attorney. Okay, and consider filing a patent application. Don't sell your invention before filing a patent application, and don't publicly use your invention before filing a patent application, because if you do any of these things, you're going to lose your ability to obtain a patent in nearly every country in the world, except US, Australia, and Canada, which has a 12-month grace period, okay? Japan, the UK, and European Union have a 6-month grace period, but it's very, very limited, okay? So you have to file a patent application within the grace period to preserve your rights, your patent rights in those particular countries. Okay, so one way of protecting your intellectual property is with contracts, and you can pull some examples on the internet. And if you want to, I could send you the ones we use. Okay, so you want to have folks sign a non-disclosure agreement. Those are also called confidentiality agreements or confidential disclosure agreements, but a lot of times folks aren't going to want to sign those, just to let you know. So if you get into that situation, then don't disclose enabling information about your invention, about your product, about your technology. Okay, if you have data that's proprietary, some folks do, then use what's called the data use agreement. Okay, and I apologize for that mistake. It should be DUA, not DAU. Okay. Also, if you have a biological material that you've come up with, for example, a new cell line, or some even chemicals, or even nanomaterials or plant materials, use what's called a material transfer agreement to protect that material. And what these agreements do is they set the rights and obligations of both parties, you and whoever you're providing that information and technology to, and it sets restrictions on what they could do with that, and it gives you enhanced protection in case of legal disputes. Now, a lot of times with these agreements, there's going to be negotiation about the initial terms before you and the other party reach consensus and before the agreement is executed. Okay, so I mentioned enabling public disclosures. So an enabling public disclosure can be something like demonstrating your invention at a conference, or discussing it in detail at a capstone course if you're in your senior design project classes, discussing it at a trade show, or discussing it in a pitch competition or other public venue, publishing an article, posting a description on the internet, Okay, and I'm talking about a detailed description. I'm just talking about, say, oh, my invention does this. No, detailed description discusses or displays how that invention works. Okay, even discussing your invention, describing your invention in a grant application, or defending a thesis that describes your invention. Okay, and also talking too much about that invention in detail with people who haven't signed some sort of confidentiality agreement, including your family and your friends. So the things to take away from this is protect your IP with contracts. Okay, don't make enabling public disclosures of your inventions. File patent applications on your inventions that have strong commercial potential. Okay, don't file patent application on anything. Okay, if it's got strong commercial potential, then consider filing patent application. And as always, hire an attorney. Okay, so I'm going to go through 2 or 3 examples here that will emphasize some of the things that we talked about here, so they stick it in our minds. And then we'll talk about protecting your IP and ideas and inventions in pitch competitions, because some of you may be participating in pitches pretty soon. Okay, so one of the examples I like to
Rafael,
use.
do you mind if we have a good number of questions? Do you mind if we bring some of those in before we dive into the examples?
No, let's do it. Let's do it.
All right. So this first one was, how do we trademark or patent a biomedical device if it's open to public? Which risk exposure, meaning anyone can copy, or technology? So is that kind of, I think it might be really related to your points on trade secrets, but.
Okay. Can you read that to me again? That's a long question.
Yeah. How do we trademark or patent a biomedical device if it's open to public? And then which risk exposure, meaning anyone can copy, or technology?
Okay.
Their technology.
Absolutely. How you protect that device is by filing the application ahead of time before you disclose it. And we did that at UC Davis, and we did that at the University of Hawaii. An inventor, a professor, wanted to talk about their invention at a conference. We filed that application before the conference, and in a couple of cases, like a day or 2 before the conference, we'd file a quick provisional patent application, very, very cheap. But that, by filing it before the conference, then we had the protection worldwide if we chose to file in different countries. So, and the trademark you get on the product. So if you come up with a medical device and you're going to start calling it, let's see, one actual case is the professor at the University of Washington who came up with the lung monitoring stethoscope. But we didn't trademark the name, but you can trademark the name of your product, But by registering with your state office, and of course registering with the USPTO, because if you're going to get a medical device, trust me, you're going to be doing business all over the country. Okay. Other question?
Yeah, so this one's kind of related to competitions and like startup weekends, hackathons. So the context is, a lot of young entrepreneurs hesitate to share their ideas during these events and or pitch competitions, thinking they'll get stolen, or they won't be able to protect it. What do you suggest to empower them to share their ideas, and any basic protections for those ideas?
That's a very good question, and I'm actually going to answer that after the examples.
There we go.
Yeah.
And let's do 2 more, and then we'll hop into the examples, and then we can do the rest at the end. So why do investors never sign NDAs during pitching? And then, how do you kind of balance that with them asking for insight into the tech during the due diligence process?
Okay, it's a very good question. I will be covering that later. But the reason why most don't sign confidentiality agreements, same reason why most people don't want to sign it, is because if they breach that, you can sue them. That's why. Okay, and I will explain how you can protect yourself.
Okay. And then
And there will come a point though where, okay, if you're going to be put in a position of revealing too much, then you're going to have that confidentiality agreement, non-disclosure agreement. And if they're really interested in it, then I think a number of them will sign.
all right, last one, and then we'll hop into the case studies. Was are you allowed to put a trademark on your site if you intend to trademark it, or does it have to already be granted? And then can you use the C for copyright on your website since it's protected once you publish it?
Okay, you can use the C on anything that you put in a fixed tangible medium, even if it's not published, okay? Like if I wanted to, I could put a C on these slides. Okay, now, the other question was? I think it was a trademark question,
Are
right?
you allowed to put trademark on your site if you intend to trademark it?
Well, you could put, if you haven't registered your trademark with the USPTO, but you're using that name for your product, for your company, what you do is you put the TM or the SM. If it's a service, you use the SM. If it's a product, you use the TM, okay? What that does is you're notifying people that you are using that name for business, for your product, for your company, even though you haven't registered it yet. Yes, that's how you put people on those. And once you register and get that registration, then you put the little R in the circle.
Perfect. Sounds good. Well, let's go through the case studies and then we'll tackle some of the additional questions here that we have.
Okay, and I'll go through these quick because I want to make sure you have time for questions, but I use these case studies because they illustrate a point of some of the first two of what not to do, I guess, you know. So, okay, first thing is the hula hoop that was invented a long time ago. The patent was filed in 1959 and issued in 1963. That's almost 4 years later, okay? Okay. And I mentioned before that you may want to do the quick examination, pay the extra $1,000, you get the patent in 12 months, okay? This patent, which is very easy, only 3 pages, took 4 years to issue. And you can click on the hyperlink and check it out, okay? So little background on this, back in 48, there was someone by the name of Spud Mellon, and he had a friend, Richard Nair, and they founded a toy company in their garage called Whammo. Their first big hit was the Frisbee, the flying disc. They came out with that in 57. That same year, Joanne Anderson from California brought back a bamboo exercise hoop from Australia and called it a hula hoop. Her husband Wayne showed it to Spud, and they made an unwritten gentleman's agreement to share any profits from sales of the hula hoop. Can anyone see that there's a potential for a mistake there? The unwritten gentleman's agreement. Before the patent was issued, Whammo got a trademark on the name hula hoop, okay? A year later, they started selling that hula hoop for $1.98. Sold 25 million in 4 months. And they started, and I've told you don't sell or use your invention before you file a patent application. By Whammo doing this, they lost their ability to get a patent protection in practically every country in the world, but the US has a 1-year grace period. So 10 months after they started selling it, they filed a patent application. Next 2 years, they sold 100 million of them. Okay. But Spud weaseled out of the unwritten agreement and paid Joanne and Wayne nothing. Joanne and Wayne sued Whammo, and in 61, after they paid their legal costs, they were left with less than $6,000. The patent finally issued in March of 1963. So let's go 60 years forward in time. Okay, that patent expired back in 81. Back then, Patents expired in 70 years from the date that they were issued, or 20 years from the date they were filed, whichever was longer. Now it's 20 years from the date of filing. Okay. 2018, if you have some time, you can watch that 10-minute film in which Joanne explains how they were kind of like cheated and weren't able to benefit from this invention. And hula hoops and hoop toys are still selling today. Okay. This other case study is about prior art. Okay. And the patent office uses a term called anticipation. Okay. And under patent law, a claim, the invention can be rejected when that invention is anticipated. In other words, it's not novel. In other words, it was disclosed in the prior art before, and the patent office will use anything as prior art to not grant a patent on an invention. And as I mentioned before, they'll use your own manuscripts. They'll use your own work against you. So there's a true story. Back in '64, there was a freighter with sheep that was docked in Kuwait Harbor, and something went wrong and it capsized. 5,000 of the sheep died. They went to the bottom of the harbor and they started rotting, and there was a fear that they would contaminate the drinking water, the city's water supply. So they had to raise that freighter up fast. And there was a Danish engineer named Carl Kreuer. He came up with the idea of filling that freighter with buoyant plastic balls to bring it up to the surface. Okay. So the reason why they didn't use a crane was because they thought it would break the hull and the ship would remain at the bottom of the harbor. So in December '64, Carl started filling the freighter with 65 tons of polystyrene balls, 27 million of them. Lo and behold, the freighter was raised. Carl and the ship saved the company, the insurance company, $1.5 million. He filed patent applications in 4 countries. And this is the patent application from two of the pages on the patent application from the UK Patent Office. Okay. But there was an examiner in the Netherlands Patent Office who did a really thorough examination of this application, okay, and refused to grant a patent on this method for raising a ship, because the examiner determined that it wasn't novel because he found it described in the prior art. So the source that the examiner used was a 1949 Walt Disney comic book, in which Donald Duck and his nephews Dewey, Huey, and Louie used ping pong balls to raise a ship. Okay. And that is the comic book that the patent examiner used to not grant this patent. And the patent office has used comic books before, has used movies before to invalidate, to not grant patents on inventions. Okay. Last example I'm going to use is we had a Sac State student transferred to UC Davis who came up with a universal ramen cooking container. Have any of you seen this out there? That's what this fellow invented. Okay, so Chris Johnson, he's a local person. He's graduated from Florida High School, was recruited by many colleges, including Sac State, Harvard, West Point. He attended Sac State for 2 semesters, transferred to UC Davis. Okay, while at UC Davis, he accidentally microwaved the perfect bowl of ramen. Okay, came up with the idea for the rapid ramen cooker. 2002, got his BA in communications, graduated. His attorney connected him with Chico State students, and they developed the first working prototype for only $500. 10 years later, filed a patent application. Okay. Chris was the sole inventor on that patent application because not everyone who works on an invention is going to be considered an inventor. Those students at Chico State were just a pair of hands. Chris was directing them, telling them what to do. Okay. And you notice from 2002 to 2012, that's a 10-year period. So he kept his invention confidential. He didn't provide anyone with enabling information to be able to make that invention. So he first started selling it at the UC Davis bookstore, then at the Walmart. Sold for about $6, cost $1 to make. And then he started getting some sales. So he goes on Shark Tank, okay? Episode 503, week 3 in 2013, because he needed money to build up inventory to fill many orders. And he asked for $300,000 for 10% equity in his business, which he called Rapid Brands. And the text in white is the dealing that went back and forth between the Sharks and Chris. You can read that at your leisure. But finally settled with Mark Cuban for $300,000 for 15% equity. However, after the show, they couldn't close on the deal, okay? So a lot of times you see something on Shark Tank, those deals don't always close after the show. But actually, that was a good thing for Chris. Why? Because 2 weeks later, people started buying up these rapid ramen cookers. You know, he started selling them at other stores, and the demand just skyrocketed. Finally, 2014, 2 years after he filed the patent application, the USPTO published the patent application. Yes, the USPTO will publish your patent application even before they decide whether or not to grant a patent on your invention. Okay, so 2014, 2 years later, no, that's the following year, is it? No, same year, 2014. He started creating additional microwave cookers for brownies, pizza, rice, vegetables. In the following year, the patent on his rapid ramen cooker finally issued 3 years after he filed it. Okay, so 2016, he partnered with Nissan Foods, developed a top ramen branded cooker, executed licensing deals with Disney and Nickelodeon characters on it. 2022, by last year, you know, his company is the fastest growing microwave cookware company in the world, $100 million in lifetime revenue. There's a picture of Chris there, Shark Tank. Okay, so protecting your ideas, inventions, IP during pitch competitions. Okay, maintain the secrecy of trade secrets. Don't share any trade secrets. Register your copyrights. Register trademarks for your products, and file patent applications. You want to keep accurate records of all communications that are substantive. Okay. Save the emails, letters, text messages, with dates. Summarize phone calls, meetings, and pitch competitions in writing. Okay, you want to execute agreements. Okay, but it's unlikely, very unlikely, probably won't happen that pitch organizers, judges, and audience members will sign them. But limit the information that you disclose. Disclose basic information, enough that's going to spark interest, but it's going to prevent misappropriation of your ideas, your inventions. And again, don't disclose ever enabling information or trade secrets without a written agreement, okay? Because you risk someone expanding your ideas, an audience member, and filing an application first. And the US now is on first to file system. So whoever files the patent application first is going to get the patent, even though they might have invented it after you, okay? And I just want to give you a couple of examples of pitch competitions that are out there. The Queen's Pitch Competition in the Queen's University of Charlotte, in Charlotte, North Carolina, in the fine print. they mentioned confidentiality of information isn't guaranteed, and teams should not include any confidential information in their submissions, including trade secrets or other proprietary information that could be at risk, okay? Another university, Mount St. Mary's University, under terms and conditions of their pitch competition, they mentioned that the applicants are solely responsible for the confidentiality and legal protection of their ideas. At Montclair State University in New Jersey, they require their pitch competition participants to sign an 11-page pitch competition agreement. Article 7 of that agreement mentions that each team is responsible for protecting the IP of its team members. And the Article 7 also mentions that the university doesn't require any individuals participating in the competition or attending the pitch events to sign non-disclosure agreements, okay? So the team and its members should take appropriate action to protect their IP prior to the competition. Okay, next few slides have some helpful resources. What questions are out there, Cameron?
There's a good number of them. I don't know that we'll be able to get all of them in the next 3 minutes.
I will stay here as long as it takes. Whoever wants to stay longer, if that's okay.
Sounds good. So let me scroll on up here to where we last were. Right, there was a we did the NDA. Sorry, I'm just trying to find, because there's been a good number of them come in. So how does IP law approach ancient common knowledge such as Ayurveda and just other natural organic products using that knowledge?
Okay, those are not protected by patent rights or any rights that they've been used for a long time. Okay. However, there are some treaties out there. One of them is the Convention on Biological Diversity. The U.S. is not a party to the agreement. I think the U.S., the Vatican, and one other country didn't sign it. And if you bring materials from one country, certain materials, to this country, start making money, those laws require you to share profits that you make from the sale of that product or that material. In one case in point, I want to give an example. We had one of our researchers at UC Davis who brought some corn that would grow at altitudes from sea level to the mountains to the US, and didn't get the proper channels, didn't go through the proper permissions to do it. And UC Davis wound up spending like 6 figures in legal costs to trying to, protecting that professor from getting in trouble and the university from getting in trouble. And I had done a material transfer agreement with a village in one of those towns for that corn. And the village elders, actually all the people in the village, they were indigenous, that they voted on whether or not to share that corn. And it was signed by one of the elders or leaders in the village. But there was another variety of that type of corn that was brought here without such an agreement. And that raised some issues for UC Davis. So for certain things, those laws apply in those countries. So if you bring stuff in here, they can cause some challenges for you. But things that have been used for years, for long ago, you're not going to get patent protection on, but you can create a product with them and get trademark protection on that product.
Good. And we'll continue with the questions. Just if people have to hop off, we will be sharing the slides and the recording to this. So feel free to, if you do need to go, just want to make sure that if your questions are in the chat, they will be answered as we kind of go through this, and or you can respond to the email with those, and I can make sure those questions get to Raphael. But
Yes.
continuing with that, there was a question related kind of from your perspective. What key experts do you believe an entrepreneur should have around their team in addressing IP, and maybe at kind of that early stage when it's more of an idea?
Well, it's always good to have someone who knows about IP, but most teams are not going to have someone. So find someone who can provide that information to whether it's, talk to someone at the tech transfer office at a university, or and of course, they're not going to give you legal advice, but they will provide you information that you will find useful. But if you can get someone on your team who knows about IP, best have an IP lawyer, but it's probably not going to happen. That's the best thing to have. And if you don't have that person, ask. I think most people are willing to provide you with information. Most people who know about IP.
Perfect.
Don't be shy about asking.
Yeah. There was multiple questions around TM and SM related to like websites and or apps. Would you consider those to have a TM or an SM mark?
Okay, that's a very general question, and it would depend on what your app does. For example, if you come up with an app that you can use in an amusement park to find out, okay, which lines for rides are shorter, and the app will suggest which ride to wait for. Well, that's more of like a service, okay? If you have like an app for like Uber, that's a service, okay? So generally those will be services, but you can still use the TM for the name of your company. You can use the TM or the SM, and once you register it, just use the R.
Perfect. All right. Let's see how to. So what about like unique methodologies? So like the McKinsey way or Lean Six Sigma. I know we talked about in our last one, like say you created the Lean startup or a Canvas. How might you protect those types of things?
Okay. A lot of methodologies, that's a hard question to answer. It would have to be you can get a patent on say a method for manufacturing a product, but when you're talking about a business method, those are very hard to patent, a business method, okay? But if it's a method for manufacturing a compound, a method for manufacturing a material, those are easy to do. But when we talk about business methods, those are very, very difficult to get patent protection on. If you come up with a business method, sometimes you might want to keep it a trade secret if you can.
Very good.
Yeah.
And then, so this was related to the hula hoop case study. Just the question was, how was it possible to even patent in the US when it was already part of Australian culture?
Okay, that is a very good question that you asked. What they used in Australia was a wooden hoop. And actually these wooden hoops have been used, I want to say, for over 2,000 years, okay? But the patent application for the hula hoop was, it's a tube, a hollow tube, okay? And it included dimensions of the width of the tube and the width of the whole hoop. Now, this is 1959 when he came up with the idea and filed a patent application, like a year later. Okay, back then they don't have the resources that they have now, computers, internet, so it was a lot harder to do a prior art search back then than it would be now. And I think, hey, they might have just gotten lucky. The examiner probably didn't do a thorough examination and probably didn't know much about Australia or these wooden hoops, because they might have determined that, hey, this is obvious, okay, coming up with a tubular hoop compared to wooden hoop, so I think these days it's a lot harder to get away with something like that.
Right. This looks like the last question here was, if the USPTO published your technology before approval, how would you stop someone from copying your tech after the patent's issued? And then how do we protect our tech if a copy can be done with just minor changes? So they see it and make a small edit to it.
Okay, those are two very good questions. The US Patent Office publishes these patent applications. That's the way of putting everybody on notice that you filed a patent application on this invention. If someone else starts making it, they're infringing on it once that patent is issued. So once the patent is issued, you go back to whoever might have been selling your invention and say, okay, you have to pay me royalties or else you got to stop doing this. Okay, or you have to get a license for my invention to continue selling that product, or else I'm going to sue you. That's how. Now, was there another question too that went with that?
It was just so say your patent is approved and becomes issued. Thanks for the terminology there. And someone just makes minor changes, but it has different impacts. It says, how do we protect our tech if copy can be done with just minor changes?
Okay, that's a very good example. Okay, if someone makes minor changes to your invention, guess what? They need a license from you to practice that improvement, because their invention with those minor changes, your patent dominates that improved patent, okay? Because they can't practice your invention. They can only practice the improvements unless they get a license from you, and they can't practice the improvements because in order to do it, they have to use your invention. So they have to license your invention from you.
Very good, very good. All right, we had one additional question. This will be the last one since we're already over on time here. What if you want to patent an invention that uses someone else's invention to do it? So I think similar to that last one, but maybe less of you being the person that someone's building on, you're building on someone else's invention.
Okay, before you file a patent application on something like that, unless the patent is going to expire on that original invention, like in 2 years or 3 years or something like that. But if you file a patent application on an improvement, it would be a good idea to contact the owner or the licensee of that invention, okay? Because sometimes, usually those inventions are licensed exclusively by a bigger company, and let them know that you come up with an improvement. You can have them sign a confidentiality agreement. And in some cases, they might be willing to license that from you, that even though it's dominated by their invention, by their patented invention, they may be willing to license it from you. But if they're not going to license it from you and that patent still has a lot of patent life, well, it may be difficult for you to commercialize that invention.
Very good, very good. All righty, well, that brings us to time here. Want to say thank you, Raphael, for leading the charge on this workshop. Really great content. For anyone that wants to go back over the slides, and there are some that were hidden that will be additional areas for you to pursue, feel free to check that out. We will be following up with the slides as well as the recording to this, and feel free to reach out if you have any additional questions. But thank you again, Raphael, and thank you all for being here. I look forward to seeing you about the ecosystem. So thank you again, and have a wonderful day.
Have a wonderful day. Thank you. Thank you.
All righty. Bye-bye.
Bye.